Hi, everyone. Welcome to part two of the Appellate Brief Writing Seminar with Judges Glasgow and Cruser. This part two is going to continue talking about effective appellate brief writing as well as cover PRPs and motion practice. I'm Gideon Newmark, Appellate Program Manager for the Washington State Office of Public Defense, if you don't know me. We will have links in the chat for the CLE reporting form, as well as the evaluation if you're attending this live. If you are attending it, if you're watching the recorded version on YouTube, please check the video description for the activity code. And that's all I'm going to say since this is part two, it's a sequel. I'm just going to turn it over to the judges.
Thank you, Gideon, and it's good to see everyone again. Just a quick couple of housekeeping things first. Just like last time, if you have a question as we're going along, if you can type it into the chat function, and then Gideon will interrupt us. He's going to keep an eye on those questions. And we also are grateful for your patience with the awkwardness of remote presentations. So when we have Wi-Fi challenges, we might switch our video off to maintain our Wi-Fi, and we are both dealing with double screens. So if you see us looking up or away, we're just looking at our screen. So we apologize for that. So we're going to get going because we have a lot to cover today. We're going to finish the rest of the brief writing CLE and then move on to some appellate procedure, and hopefully we'll get to oral argument as well. So Judge Cruser is going to start with talking about the facts section of a persuasive appellate brief.
Hi there. Yes, I'm sorry to not be on video. I'm having some internet issues because I'm sharing Wi-Fi with several kids. So bear with me if you would. So going to the facts part, when I was an appellate lawyer, I guess I didn't realize just how important that section of the brief is. It's not just about getting out the facts that you're going to need to use later in your argument, but it's also about telling a compelling story. One thing I would say is, make sure that when you're deciding which facts to include, that you're only including the facts that will either enhance a compelling story or that you're going to be using later in your argument. I don't mind extraneous facts in the facts section if they're not explicitly used in the argument section, if they're still part of what you need to tell your story. So you want to really look at that. And if you're including facts that don't do either of those things, they're not going to play a role in your argument, and they don't really help your story, they're distracting. I would say that sometimes I'll see facts in a factual statement and I think, wow, I wonder if there's going to be a big argument about this, and then you'll get down in the argument section and there's nothing about it. So, make sure not to include distracting extra stuff that's not helping you. Make sure to include the items that are required in the rules. I would say, we talked a little bit about this last week, including the text of a jury instruction that you're challenging, or at least having it as an appendix, and including the text of any findings of fact and conclusions of the law that you're challenging. Also, I would say, include negative facts. It does help soften the blow. I would say it's pretty surprising when you get to the other side's brief and, they're including all sorts of facts that I think I've been doing this long enough not to feel explicitly misled, but it does, it's a bit jarring to see a negative fact that wasn't included in your brief. It almost gives it a little bit more power. So I would always include those negative facts and tell them in a way that still doesn't interrupt the compelling story you're trying to tell. Judge Glasgow, anything you want to add?
No, I think that's great.
Okay. All right, so, what I prefer, and Judge Glasgow can talk about this as well, is that you tell a chronological story, which doesn't necessarily mean telling the story in the order of when the witnesses were called. You do tend to see that quite a bit, not necessarily in the briefing of you folks, but just in general, the briefs we get, going through, well, this witness said this and this one said that, and sometimes the witnesses aren't called at trial in a way that makes sense when you're trying to tell your story on appeal. So I would say I prefer to have it told chronologically because I find it distracting when it's not, because I find myself having to go back and try to piece together the chronology of events. And again, the robotic sort of listing the witnesses in order is not terribly helpful. Now, if that's how the chronology is as well, then I suppose that's fine. But, and again, this touches on the avoiding unnecessary detail. Again, it can be very distracting, and because your brain is gearing up to, oh, I know this issue, I know what they're going to be talking about, and then I'm reading the rest of the fact pattern, waiting to get to this interesting fight about this issue I think is going to be there because of the fact you included, then it's not. So I just, really want to encourage you to pay attention to things that that you think might distract somebody who's less familiar with your case. By the time you're writing your brief, you've been living with your case for a while, and it can be hard to sort of piece out, what you think a reader who's reading it cold is going to think about your case. So I do, as I think I mentioned this last week, and I can't speak for Judge Glasgow, I read the briefs first and I read them in order, and then I go to the record. I don't do the record first. And so the appellate brief, the appellant's opening brief is really, really important. Judge Glasgow, do you have anything to add?
Yeah, I agree with that. I read the briefs before I read the record too. So you're absolutely right about that. Okay. So just as a quick comment, you'll notice that we put in the tricks or the tips for writing the argument section before we covered the facts. I did that just as a point of personal privilege because that's the order in which I used to write my appellate briefs when I was writing them. Of course, you can write your facts first, but I always found it helpful to write facts after I knew what the arguments were going to be, because then my facts were more targeted towards the actual arguments I was making. And I was outlining first so that I wasn't sort of writing blind as I was writing the analysis. So going on to introductions and conclusions, Judge Cruser previewed this a little bit because she emphasized last week the importance of an introduction, and I think good conclusions are equally as important. I find introductions, especially in the appellant's brief, to be super helpful to focus me on the things that you think are the most important things for me to know about the case. Going back to what we talked about last week with Chief Justice Stevens' advice to focus on both passion and permission. So sometimes the introduction can be a little bit overwhelming. I used to leave it till the very end of every single one of my briefs because I did not want it to, I wanted it to be really efficient and tight. And the only way I could do that was if I had written the rest of the brief first. And I always found that the Ross-Guberman model for introductions was the best place for me to start, because he gives a very simple roadmap that would always get me going, even if I was feeling a little bit of writer's block, because he just has slots and you just fill in the each piece of the introduction based on your case. So his first tip is to make sure that you have a strong opening sentence, and if at all possible, that it addresses the crux of your case. So if you can figure out what the most important issue is and target that issue in your first sentence, either by describing a compelling fact that's related to that issue, or by explaining the crux of that issue. He also then says the next step is to launch into a very quick newspaper style description of what's going on in the case. And so you can think of it like a newspaper reporter and try to tell us in a few sentences who's involved in this case, what happened to get us here, and if possible, tell us what's at stake, right? Try to make us care about this. Then you want to weave in, then you want to say in a bullet list kind of fashion for your major issues, why do you win and what your most persuasive arguments are. And then into that basic framework, you can then go back and figure out whether or not you've weaved in that passion that Justice Stevens talks about. So have you worked into your introduction why it is that the court should care about ruling in your favor? So there are multiple ways to think about that. One of them is to think about sort of the inherent justice of the situation. Sympathy for your client is another thing to think about, but also remember that judges are always thinking about the system as a whole. So are there any systemic issues that you can trigger in our minds or get us thinking about that would make us want to look at the case from your perspective?
So we have a question, which is about including facts in your fact section that you know are going to be relevant to the issues your client will raise in the statement of additional grounds. Do you have a perspective on that, whether it's a good idea or not?
So was that, I'm sorry, was that in the introduction or in the fact section?
In the fact section.
Yeah, I think that, so I see that question. It's a great question. I actually really like the idea that's posed here about putting it in a footnote, maybe to the effect of, you know, I'm including the following facts because my client may wish to address them in his or her SAG. I think that's a really good idea because it is, you know, it reminds the reader right away that, you know, because sometimes when you're reading the appellant's opening brief, you're thinking of it as the closed universe of what's going to be argued. And then you remember, oh, okay, now I'm getting to my SAG. I tend to read, I typically will read the SAG after I've read each of the 3 briefs. But occasionally I do read it right after the appellant's opening brief. So I do think that's a really good idea to include that as a footnote. And then this next question looks maybe for like you, Judge Glasgow. The question is, do you suggest always including the optional introduction section, even if it is a shorter brief raising a single or only a few issues? Do you want to touch on that?
Yes, I think that you should always have an introduction because they are so helpful to us as we are cracking the brief. If for no other reason, then sometimes I'm you know, remember that judges are human beings. I'm turning to these briefs with a long list of other things on my to-do list, on my mind, and stuff going on. And it's your chance to sort of grab me by the shoulders and help me focus on what you want me to focus on. And so even for the shortest brief, I would say that I would like to see an introduction. And when I worked in the Solicitor General's division at the AG's office, that was one thing that Noah Purcell, who was a Solicitor General, insisted on for every single brief, and you would be astounded at the amount of time that we spent on introductions for briefs that we were writing for the state Supreme Court, the US Supreme Court, and the Ninth Circuit. Sometimes we would spend a whole day on an introduction for a really case that was either high profile or was really important to the client or involved a lot of administration folks. So I can't say enough about how much I think an introduction is helpful. So I put up on this slide a sample introduction that I pulled out of a brief that I came across in my old job. And if you can take a second to read it. So while I say that we should have an introduction in every brief, please make them not look like this. There are 2 main sort of pitfalls that come up in this example that we see a lot. One of them is this introduction isn't doing its job because it's not persuading me that the person that wrote it has the right argument. I can't even tell what side they're on or what the case is about. The second thing, and you guys, I don't see this issue come up with you guys very often, if at all, but it's a good thing to remember. I really hate the alphabet soup of tons of acronyms and initialisms, and when they're all packed in the introduction, it makes it really, really difficult for us to wade through, especially if it's an area where we're not familiar with the acronyms in the way that you are. And so my recommendation would be to rewrite this in that Ross Guberman style, where you're explaining what the crux of the case is, why it is that you win, and what's going on in the case, and then weaving in why it is that we should care about the outcome of the case. Judge Cruser, did you have anything to add about introductions? And
yeah, well, I guess I would concur with what you said. This introduction isn't telling me anything, but I would also really strongly echo what Judge Glasgow said about the acronyms, because I'm not sure about anybody else, but I have, when I look at certain letters, I have this thing where I see them in colors. And when I'm seeing all these C's, I'm just, my brain is sort of getting confused. It's going to take me longer to get through the brief with these acronyms. So DOC is one I think that we all recognize without any difficulty whatsoever. But here's an example of where I would just refer to this Mission Creek Correction Center as Mission Creek throughout the whole brief. I'd just call it Mission Creek. I'd find a way to talk about a certain, entity, maybe by their name and not by using, a string of letters that can just be really distracting as you go through the brief. They're a lot more distracting than I realized when I started reading it, from this side. So I would just echo that.
So now Judge Cruser is going to talk about reply briefs.
So I think that a good reply brief, just like the slide said, is short and punchy and selective. We don't really want it to be the full page limit, because then it just looks like a reiteration of everything you said in your opening brief. I think that you're really trying to zero in on the points that were made by the opposing party and say why we should not find them persuasive. And either because they're relying on an apposite case law, the reasoning is flawed, whatever it is you want to point out to us. And so, I think a good reply brief is very effective. But if I'm not saying it's necessary in every case, but I do think they can be very effective. Some of the situations where maybe they're less effective is where, maybe it's a settled legal issue. You're arguing about the trial court having imposed LFOs it shouldn't have imposed, or things of that nature. Because I do understand that you have a lot of work on your desk, a whole lot of work. And sometimes cases don't necessarily, call for a reply brief. But when they do, I think shorter is better and really just give us a succinct summary of why it is the other side got it wrong. Judge Glasgow, anything to add?
No, that was good.
All right, so on this one, I think, when time is crunched and you're trying to get something under a deadline, and maybe you need to ask a colleague who doesn't have the time to spare to help you, I understand all of those things. But if you can, it's better to have somebody else give a quick read of your brief, not necessarily to argue over every comma or every, I think this should be a semicolon, more like, hey, do my arguments, are my arguments compelling, and do they make sense? And then also, if you have the time, and I understand if you don't, it's good to write the brief and let it sit for a day or two and then go back to it, because then you'll say, okay, well, now I'm seeing that this paragraph is not needed, or this argument could be said in a better way. And so, if time does permit, I think it's always better to let it sit for a day or two and then go back and look at it again. Judge Glasgow? I think we have a question, actually. Let's check. Let's see. So the question is, do you have any suggestions in dependency and termination appeals for references to the parent-child by something other than initials? Yeah, and it says, do you see this as not a problem? That is a great question, because that's a real difficulty that you don't have any power to fix. I will say that I just have to spend more time reading those briefs, because I understand that you don't really have a choice in the matter of doing initials, and it can be completely distracting. Sometimes I will make a note to myself, and I'll just, if there's a children and there's an LDH and a KDH or whatever, I'll just make notes as I'm going along, L, K. I mean, I know that you don't have that necessarily that freedom to just shorten everything in that way. So at that point, I just have to use the tools that I have to separate out the parties. But I really think you're in a hard spot with those cases because you're having to deal with really what the rules call for. Okay, here's the next question. How do you feel about calling them mom and dad? I think that's fine. I don't know if Judge Glasgow wants to get in on that, but I actually think that's great. I have no problem with that. I think that's actually quite helpful.
Yeah, and I think that's a good, we used to do that when I worked at the AG's office, and part of the reason is that you are talking to human beings and it helps us identify with them as people, because a lot of us have had the experience of being mothers and fathers, right? And so you have the extra benefit when you use those words of hooking into the human nature, right? And helping the judge connect with the position of your client.
Right. And I think there was a follow-up question, do you prefer initials or pseudonym for the parties? I think that touches on what the other question was asking, which is that if you feel like you can, I think it's fine to say mom or dad, grandmother, grandfather, things like that. You know, if you feel you're able to do it, because we understand the restrictions that go along with those cases.
Yeah. Yeah.
Okay.
Good job.
Okay. All right. So editing for clarity and efficiency. This is, you know, somewhat what we've talked about before. Judges check the length of the document. If the document is long, our instinct is to read fast, and if short, to read slower. I think that's absolutely true. You know, obviously we're going to read the whole brief, but it's not so much that your shoulders sink when you see that it's 49 pages, but they kind of do. And you just got to buckle up. And it also, you know, sometimes I'll have to put that, I'll say, okay, I've got 5 other briefs that I think I can read faster and more efficiently. I'm going to put this one off until tomorrow morning when I can book out a lot of time. And so, but I think, you know, to the extent that you can, and we all have learned this all through school, you know, shorter is always better, but it's more difficult, I think. You know, you all don't have that freedom because you have to get out your assignments of error, and you have to, and you're also writing for the client. And I understand that. You know, I attended a CLE a few years ago with, there's a civil appellate attorney, Ken Masters, was giving this presentation, and he was sort of saying, you know, why would you ever file a brief with all these assignments of error, and he was kind of going on and on. And then at the very end, he said, oh, but this doesn't obviously apply to criminal attorneys, because we understand that you have to get out your assignments of error. You have to make your arguments. And if it takes 50 pages to do it, that's just the way it's got to be. So, but to the extent that you're able to make it shorter, that is going to be more persuasive. But I think Judge Glasgow, we understand that sometimes you can't, because you have to get out your argument, and you're also writing for the client. Judge Glasgow, anything to add?
No.
Okay. All right. And this is sort of something that Judge Glasgow talked about. She's a big fan of checklists, and I wish I had done more checklists back when I was an appellate lawyer. So obviously, you know, have you addressed all possible barriers? We talked last week about how it really is important for you to bring up the barriers you might be facing, rather than to make me wait and see when the state files their brief, what those barriers might be. You know, positive argument first, roadmaps and transitions, strong topic sentences, tone, block quotes and string cites. So I think that it's a good thing to have a list like this, so that you can go back when, you know, if you've had the luxury of letting it sit for a day or two. Particularly tone, I think, is important. You know, we have, you know, from time to time, you'll see, you know, there was a prosecutor who had filed a brief. This prosecutor's now, I think, retired, but, you know, one of the things that was notable about this person's brief was a really negative tone, talking in personal ways about the defendant or defense counsel. Just, you know, that's incredibly off-putting. The minute that there's a personal sort of tone that that seeps into the brief, it becomes really not a pleasant read. And frankly, I don't think I ever see that in the briefs filed by you folks, ever. but it is a good thing to check your tone. Block quotes, you know, I don't mind block quotes as much as some of my colleagues probably do. I don't necessarily like them when they're a page or a page and a half, but sometimes a block quote is the best way to say what you need to say. I prefer them shorter if possible. I really think if it's getting to be more than 2 paragraphs, you've got an issue there. But I don't necessarily have an aversion to them like some of our colleagues do. And then of course, some of our colleagues have a real aversion to string cites. Judge Glasgow, did you want to add?
No, just on the block quotes, we do understand that they're necessary sometimes. Justice Madsen had a really good tip that I always tried to follow, and that was to always lead into your block quote with the punchline, so that what you're doing is encouraging the reader to read for that, whatever it is. And so that sort of engages their brain as they're reading the block quote, rather than just having it flat, where people are really tempted to just skim. And so if you look at block quotes in Justice Madsen's opinions, you'll see how she does that. She does it every single time. And that will show you how to do it. So of course,
I think we had a question that's relevant to that, since you mentioned roadmaps. We have an attorney asking, I often start each section of a reply brief with a quick review of my arguments from the opening brief to provide context before I identify and criticize the opposing arguments. It sounds like you're recommending against that style.
So not necessarily. I think that can be really effective. What I really find more difficult to stick with is a whole brief that just rehashes what you said in the opening brief. So I think it's fine to give us a quick review and then launch into the specific points that you want to make about how the respondent's brief got it wrong. What do you think, Judge Cruser?
Right. I think that if you're talking about, you know, in the nature of a quick introduction, just refreshing the reader about, you know, here's what's at stake, here's what I've raised, and here, you know, here's what I use to support my claim, and then launching into why the respondent got it wrong. I think, again, as long as you're keeping it succinct, I think that's fine. In fact, I think that's probably helpful. I think I would just echo what Judge Glasgow said, instead of having it be just a really sort of a 20-page recitation of what you said before. There's a way to do it, but I think that actually can be quite effective to do that brief initial summary.
Yeah, I mean, for my part, I know I'm not the trainer here, but you know, if I understand the question, I would say it's, if you're starting with a section of, here's a section of recap of my argument, then you get into the meat of the reply brief, that's probably less helpful than if you incorporate it into the argument. So like a sentence reviewing your argument versus like a section at the start of each like a subsection at the start of each section, you know, that's sort of an organizational breaking things up and breaking up the flow potentially. That may be hard to visualize for people what I'm talking about, but that's kind of how I'm seeing it.
And reply briefs, I think, are, they can be beautifully done, and it's really wonderful when we get a good one. I think a lot of what I did when I was early on in my appellate career is I tried to find people who I thought were really spectacular writers, and then I would dig up their briefs or even ask them to send me copies of some of their sample briefs that I could read. And I was in the civil world, so I had probably a different pool of people that I was drawing from for that. So, but in the civil world, it's like Howard Goodfriend, Noah Purcell, Narda Pierce. Those folks were the people that I turned to. I don't want to embarrass her, but I have seen some really fantastic briefing from Lila Silverstein. So she would be the person I would turn to in the criminal side. Judge Cruser, do you have any other thoughts about that?
Oh, just, you know, in terms of going to others for editing, I think that, the briefs that we're seeing from this group are really good. And any colleague that you are able to connect with who can give you some time to look it over, if you're not able to, if you don't have the time to stop and sort of give it a rest and do it yourself. So, I've been there, solo practitioner, trying to call on colleagues for help, and everyone's busy. It can be very difficult. But like I say, even if you can't have someone else, work with you, it can be helpful to let it sit for a day or two, just to go back and have another look at it and see if you really like what you wrote.
Yeah. And then just reading samples of these folks' briefs, so you sort of are internalizing some of the things that they do well. Okay. So of course we have to include pet peeves. We get this question quite a bit, and Division 2 does have some folks with strong feelings about little things. So we thought we'd take the opportunity to share those with you. I did ask a couple of colleagues if they had any thoughts about what we should share. And the biggest one for you guys as a group was the sentiment that folks really get frustrated when they get a very long list of assignments of error combined with the failure to argue all of them in the actual text of the brief. And so what that does from our perspective is it makes us sit down with the assignments of error and then go fishing through the brief to try to figure out whether or not an assignment of error has been adequately argued in the briefing. And so the colleague that I was talking to sort of described it as a failure to go back and recheck your assignments of error after you've finished writing your facts and analysis to make sure that you've covered all of your assignments of error and they're in your briefing in one way or another. And so that was the #1 suggestion that I got when I polled some colleagues about sort of their pet peeves. Judge Cruser, did you have anything to add about that? Do you have any tricks for avoiding that problem?
No. I think just touching on some other, we talked about that last week, and making sure that your assignment of error, if you're making the assignment of error, you have to support it with argument. I mean, there's a wrap on that, and you will find that, oftentimes the court will say, we're not compelled to consider arguments that are not made with adequate supporting authority or argument. And so you really do want to, but, somebody had mentioned last week, I think we talked briefly about the idea of when you do your issues pertaining, I sort of prefer maybe even a parentheses, this issue pertains to assignments of error 1, 2, 3, 4. Or something along those lines. And then some other of our colleagues liked it when the issue pertaining falls right underneath the assignments of error that it's going to be pertaining to. I find that a little distracting myself, but either way, just make sure that we know that you are intending for us to think that each assignment of error is encompassed in this particular argument. Sometimes it's still maybe not there, and then of course, as I said, we're not going to be able to consider if it's not adequately briefed or supported by authority. Did you have any other pet peeves, Judge Glasgow, to bring up?
We do have a question that's closely related to assignments of error, which is, I struggle with this in dependency cases with assignments of error, that is. Do we make a separate section for each finding of fact challenged, or lump them into our legal argument section that relates to those facts?
So again, I think that you don't need to make a separate section for each finding of fact challenge. I think that as long as when you're discussing the finding of fact in your argument section, as long as you're clearly identifying it, by its number so that we can see, so that I can track when I go to my notes, so that's one of the assignments or one of the findings of fact that you assigned error to, that's helpful. And again, also, if you've identified underneath your issue pertaining which assignments of error are going to be discussed under that issue pertaining, it does help me as well, because I'm making notes as I'm reading, and then I can quickly look at my notes and see what I'm going to be expecting for that section. So I don't know, Judge Glasgow, do you want to add on that?
Yeah, I agree with that. You don't need a separate heading for every single one. And remember that a lot of us are working in electronic versions, and so we can do a search within the PDF of your brief. So to the extent you're consistently naming things like FOF, 13 or whatever, then I can use my search function to get to that. And so, or you can have little tags at the beginning of your paragraphs within a section, so you don't necessarily have to use up a heading. So you can just have a little introductory heading at the beginning of a paragraph if you feel like it doesn't if you don't need to have a whole section named for a particular discussion of how the evidence in the record supports a fact.
So it sounds like we're saying it needs to be organized, like clearly organized, but it shouldn't be a list. It shouldn't be something that fails to tell the story and hold the readers into attention.
Right. Yeah. So the second most raised pet peeve is mischaracterizing the facts, or sort of, as Judge Cruser mentioned before, leaving out a critical fact that's bad for your client, and not softening the blow in your opening brief. Because then it's hard not to feel a little bit bamboozled when you open up your opponent's brief and see something glaring that was either left out or characterized incorrectly. I will say that I don't see that very often, but we do have colleagues who feel like that when it does happen, that's something that really makes them sort of cringe and have a little bit less trust in the advocate. And that's something that you want to avoid at all costs, right? And then we have colleagues who are really focused on making sure that we are looking at the most recent cases for a particular holding. Not all of us agree with that. Some of us really like to see the citation to the foundational case. But the way that I've started dealing with that in my memos to my colleagues is I will cite to the foundational case and then do a C also to the most recent published case that I can find for that principle, and that seems to satisfy everybody. But that might be a Division II quirk. I don't know. What do you think, Judge Cruser?
Well, yeah, maybe. I'll get a pre-hearing from another chambers, and maybe they're citing some principle that we all have rolling off our tongues for the last 30 years, and it cites to a Court of Appeals case from a week ago. And I'm thinking, oh, did this Court of Appeals case touch on something new? Has new ground been broken? And I'm instantly distracted, pulling up, Westlaw. Oh, no, this case is just reiterating the benchmark. I prefer to see the benchmark case. The first thing after your principle is, you're talking about, sufficiency, and you're deciding to green or whatever. I like to see the benchmark case. And then I think it's good to do a C also for the other folks on our bench who say that they want to see the most recent iteration, even if it came from outside of our division a week ago. Division III talked about this 5 days ago. I want to see it. So it's different judges have different styles. So I would say, to be safe, go with, here's the case that you would expect to see supporting this principle. And then here's the most recent court that talked about it. So.
Would you say part of the function is you want to cite the foundational case so we're all speaking the same language, but then you also want to cite the recent case to demonstrate that the principle remains valid today? Yeah.
I think that's a good way to put it. And, the principles, cited the most recent case tells me that it hasn't changed when you've also cited to the benchmark. But when I only see the most recent iteration, then I feel like, oh, is there something new? I got to go check it out. And then I'm irritated because there's nothing new. So it's just maybe it's just a personal thing. So I think the best strategy for the advocate is to do what Judge Glasgow suggested, which is, put down the foundational case and then put, C also, so I can see the most recent court that talked about it. And maybe I do want to go look at what they wrote. So.
Can you think of any other pet peeves that we should talk about, Judge Cruser?
No, just we already touched on the string cites. A lot of judges kind of don't like that, and so I think we covered it.
I'm going to switch over to our other presentation really quick.
While we're switching over, I would say, I mean, have you ever seen and been annoyed by kind of string cites in lieu of argument? Just somebody says they state their conclusion and then they string cite to say, and that's, you know, this string cite is why I win. Go fetch.
Yeah, that's a problem.
Okay, can you guys see that? Are we good?
Yep, so, looks good.
Okay. Which slide are we? Oh, are you on slide? Oh, I'm sorry.
So I'm on the second presentation, and that's the title slide. And then there's the first slide that launches you into PRPs.
And Judge Glasgow, do you have the screen for us, or are we just only seeing the slides? Because I don't actually see you or anybody else right now.
Okay. I don't know. Gideon, are you seeing more than the slides?
We've just got the slides and I've got the speaker window up for the recording. But your view might be different. You should see the screen share no matter what. But you actually have control over the speaker view, chat, participants, those kinds of things.
Okay. All right. So that's all right. I don't have the videos, but that's fine. So going to the first slide on starting with personal restraint petitions. Obviously, we want you to focus on the court rules that govern these petitions, the grounds for the remedy under 16.4. And then, of course, the big one is potentially the time bar, whether the petition is timely under 090 or whether there's an exception under 1073-100. You want to make sure you cover this. We do see a lot of petitions that kind of don't discuss the time bar, almost as though you think that the reader thinks you're not going to notice. That's not the case. So you really want to have all of your arguments set forth about why the time bar, why there's no barrier to getting relief based on the time bar for your client. And also pay attention to the form of the petition under RAP 16.7. These are things that are really important to do. Judge Glasgow, anything?
I just have a question for you. I've seen briefs recently, a couple of briefs recently, where it seems like the petitioner is saving the time bar arguments for the reply. How do you feel about that strategy?
Well, again, it feels like it's a strategy premised on the idea that the state's not going to notice the time bar issue. And I will say, oftentimes that's correct. The state didn't notice the time bar issue, but we're going to notice, I'm going to notice. So it's just much more effective to deal with it head on in the petition, and don't wait until after the other side has addressed it, because if the other side fails to address it, we as the court still need to deal with it. So it doesn't, there's no advantage to not addressing it straight on.
Well, doesn't counsel have an ethical obligation to raise controlling precedent that the other side has missed?
Yes, I think so. Yeah.
Right. So it's kind of a situation where if you strike the jackpot, if you're trying to strike the jackpot by having the state miss a critical issue, but you know about that issue, you know, that's seems to be unethical.
Yeah, I'd agree with that. But we see it more often than I'd like to see it, I guess is what I'll say about that. And it also happens obviously in the direct appeal context, sometimes with issues that are either not preserved or that were waived or where there was invited error, things like that. You know, I think it's sort of less less on the side of being unethical in the direct appeal context. But, you know, I think it's important to always deal, you know, if you have a procedural barrier, we're going to catch it. So there's no benefit to ignoring it and breezing past it and hoping the state won't catch it.
Yeah, I will say it seems like it's less unethical in the context of issue preservation, right, because the state could waive issue preservation knowingly, and it's not like it's an obscure enough issue that they're gonna forget about it. And it's also not directly, you know, like a 1 year time bar that's like it's a solid wall versus issue preservation is way more spongy. Right. So we actually have a question that's actually maybe a little bit more of a me question, or maybe a clerk of court question, but I think we can, it's pretty, you may have thoughts on it as well. The question is, what are your standards for appointing counsel in pro se PRPs? And I guess that's actually, maybe that is more of a court question. I mean, I can say that the court does its initial kind of frivolity review of PRPs before deciding whether to appoint counsel. But I guess I don't really have any insight into the standards that are used, other than essentially it's a meritorious issue standard, right?
So maybe Judge Glasgow would be better to answer this question, because I have to tell you, by the time it gets to me, when I've been assigned the case, maybe as a writing judge, and it's on my calendar and we're preparing it for the next cycle, counsel's already on board. And I don't typically go back and look at the process for how that came about. I don't question it, in other words. I don't have any dispute about it. So Judge Glasgow, do you have any better insight into when the stage at which we appoint counsel?
So I don't really have anything to add to what Gideon said about that initial frivolity review. So we have a process where at Division 2, and not all the divisions are the same, we will get petitions that have been initially flagged as frivolous to review and work on an order. Those do not get counsel appointed. If they get past that frivolous bar, or that frivolous hurdle, then they will go to a 3-judge panel, either as a no oral argument or an oral argument. And I believe that those cases get counsel, but and we have the ability, when they land on our desk after that initial screening, to change the status of them. So we can look at them and say, oh, this is not frivolous, we need to bump this. And we do that. I mean, I feel like I do that at least a couple times every 6 months. And so, but that, I don't really have more to add about that in Division 2, because as Judge Cruser said, a lot of that action happens before we get the cases.
Right, and so, and there's a sort of a disconnect sometimes when we get those initial things that might come to us for an order, and then we disagree with the initial sort of finding of frivolity. I'm not, you know, we're not necessarily going to be on the panel that later deals with it. And so, for example, when I get something that's on an oral argument calendar, I may not have been involved in the earlier stages of when counsel got appointed, but on different cases, I might have been involved in getting counsel on board when I disagreed with the initial proposal of finding it frivolous.
Yeah, I may actually have, I guess, a little bit more insight into this, because it is kind of below the level of the judges. But as I understand it, it goes through a process where, I mean, the staff attorneys reviewing it are going kind of point by point through all of the sort of bars to the PRP being raised, which includes the time bar, includes the rules on successive petitions, abuse of the writ, and then of course whether the issues are frivolous or not. And I, you know, to my knowledge, I don't know of any PRP client who got past that initial review who wanted counsel and didn't get counsel. Not that I would necessarily be notified of that if that happened, but as I understand it, once it gets past that stage, the court will ask the client for their statement of finances if they want counsel. and the client will fill that out. And, you know, since they're basically always indigent at the PRP stage, the counsel will be appointed.
Okay. All right. Now, Judge Glasgow, are you going to the next screen, or do I need to go?
Yes.
I can't. Okay. All right. So personal restraint strategies. And so I think what our staff attorneys are initially looking at are whether the petition is legally flawed or for factual flaws. And so when you're coming up with your strategy, obviously you need to be cognizant of that and what they're looking for. Judge Glasgow, when you talk about legally flawed petition, was there more you wanted me to expand on in terms of what our staff attorneys are looking at? Because I think we sort of touched on that. Yeah. Yeah,
I think that the point is really to do what we asked you to do in the last in your opening briefs for other cases, and that's anticipate what the arguments are and deal with them as early as possible. So if you're writing a brief in support of a petition, again, it's better to try to address all of those potential legal and potential procedural flaws as early as possible.
Right. And so the client has, oftentimes, the situation is the client has filed their initial petition, and then if you are appointed as counsel, you will find flaws with their petition, or that there were things that they could have, claims they could have made that they did not, things of that nature. So really look at the rules and what your options are. Obviously, if you're within the time bar, it's much easier to amend a personal restraint petition by, file a motion, file the amended petition alongside of the motion. Obviously, if you're past the time bar, by the time you have discovered the flaws in your client's petition, it does get trickier. You're going to want to look at the case law that pertains to that and figure out if there's a way that you can, amend or supplement the petition. I know those are two different things, but that you might look at doing those things if you feel that you can. Obviously, you're going to need to set forth your arguments if you are, past the time bar that you think would allow us to still consider the claim. So I know that's a really difficult position when the client has already filed a petition and there are flaws in it, to have to deal with that later. But, look at the tools you have in your toolbox to do that. All right, Judge Glasgow, anything more?
No, I will just show you this slide about the PRP procedures and principles and leading cases. And this is a guiding document that the Supreme Court Commissioner's Office drafted years ago. It was a long time ago. I used to use it when I was a law clerk at the state Supreme Court all the time. But they've updated it every year, and they make it available in the state law library. And I believe it might be available on the Supreme Court website, but they've told us that we can share it widely. So Gideon, I can send you a copy, the most recent copy, and you can make sure that people have access to it. And I always try to talk about this because this document is such a help to people like me who are coming into an appellate judicial position, and it's helpful to my law clerks as well. Without having a ton of PRP experience, it gives a roadmap of all of the procedural hurdles and all of the relevant case law. And so when I'm struggling to figure out where we are in PRP world in a particular case, this is the document that I go to. It's the document my staff, so all of my law clerks and externs go to. And so if you know that, then you can understand sort of how a new judge is approaching these PRP cases. And you can use that to your advantage by working through the same structure that this document uses for working through a PRP.
And we actually have this document on our website. under Appellate Program, Appellate Attorney Resources. But if there's a more up-to-date version, I'd be glad to get that and put that up.
Okay, I'll send you the most up-to-date one, and you can make sure that you've got the right one.
Yeah.
And then they update it every year, so it's a fabulous resource because they add the new cases. Judge Cruser, did you have anything you wanted to say about that?
No, I think you covered it.
I think we had a comment in the chat, which is that this should be made available at every institutional library because most PRPs are pro se.
Yeah. There was some talk about.
I thought they were. Yeah.
Yeah. I can check again with the commissioner's office and see.
I thought it was, and I could be wrong, but I thought it was. Okay.
Okay. So we wanted to cover a couple of quick other appellate procedure questions that come up very frequently. And I actually don't see many motions to strike in you all's briefing. So I think you've gotten this message, so I'll be fast about it. But there is a principle from Engstrom that talks about how it is preferable from the judge's perspective for you to point out improper evidence that the court should not, or argument that the court should not consider, and that's all you have to say in your brief. You don't have to bring a separate motion to strike. And so there are all kinds of strategic reasons why I think as an advocate, I found this suggestion very helpful. And when I worked in the Solicitor General's division, we used to always recommend that people not bring motions to strike, that they use this strategy instead. I also, oh, go ahead, Judge Cruser, I'm sorry.
No, I don't have anything to add. I was just nodding.
Okay. Yeah. So do you want to cover the submissions for oral argument?
Right. So, we get motions for oral argument frequently in cases that have been screened for not having oral argument. And when we're reviewing those, sometimes, the judges are thinking, is this a motion that's being made because the client has requested it, or is it a motion being made because it really would be helpful to the court? So the more you can explain about why it's going to be helpful to the court, the better. And sometimes that's even just, my client's facing a very long prison term and the case should be given, consideration of oral argument. Maybe that's enough. But really explain as much as you can about why oral argument is going to be helpful for us, and do it as early as possible because the calendars get set, fairly early. And so it's really just better to do it as early as you can. But I just, the more detailed, the better, and about why that would be helpful. Judge Glasgow, anything to add?
I don't think so, other than the judges have different views on these. My inclination is honestly almost always to grant these if I think that oral argument, if there's a slight chance that oral argument would be helpful, but not everyone shares that perspective. And so I'll just echo what Judge Cruser is saying about being as specific as possible about why you think oral argument would help.
Yeah. And sometimes I think some judges are maybe disinclined to grant oral argument because, maybe your brief has set forth an issue that we know we obviously have to reverse on, or that you're going to prevail. And so maybe that's one reason why if you make a motion and you don't get oral argument. But again, just be as detailed as possible in your motion.
And one thing that surprised me when I became an appellate judge was that I think we used to think when I was a practitioner that there was some connection between the likelihood of reversal and getting oral argument. And I've realized since I got on the bench that there's just no connection between those two things at all. And we used to
that too.
Those tea leaves, and there just is no, because of the way that the oral argument cases are identified, and they are a little bit like the PRPs in that it's a little bit of a mystery to me even now how that happens, because it's a screening process that the staff attorneys work on with one of the judges on our court. And so it's not uncommon for a case to land on my desk and for me to get through our process to the point of having a bench memo drafted and ready to circulate to the panel when I'm thinking, oh, we really should have tried to have oral argument in this case, or vice versa. We don't really need oral argument in this case. And so you are more likely to know that earlier than I will. And so if you think oral argument is necessary, it's really helpful to make a motion and say so out loud so that the judge who's been assigned to draft the bench memo in the case can hear your thoughts about that. Judge Cruser, do you have anything to add about that?
No, I just would echo, do it because, again, you will have identified that issue long before it gets under our eyes. We will, of course, we also have the ability to, when we get a case, say to our fellow panel members, okay, this was not screened right. We really do need to have oral argument. So sometimes your case will get bumped because we want to actually have oral argument. But, again, the earlier you get it under our eyes, the better. Okay.
So, we wanted to spend a little bit of time here at the end talking about oral argument preparation and strategies for oral argument. We recognize that you are really short on time. And so some of these suggestions are not things that you can implement in every case, and we totally get that. So we wanted to give you our most comprehensive lists, and then you can sort of pick and choose what strategies might be helpful. And what strategies might help you be a little bit more efficient for oral argument preparation. And so either using a moot court process or talking with someone who has had some time to quickly skim the briefs and can help you identify a list of likely questions. This takes time and it requires you to rely on some other people for help. And we know that everybody on the team is really busy. But getting a list of potential questions is really a great first step. And it really helps get the case sort of beyond just your brain into it gets you access to questions that you might not have thought of, right? And so the hardest thing that can happen at oral argument is for a question to come to you and you haven't thought about it and you haven't thought about what your answer should be. So this is what heads that off, right? That awful feeling in the pit of your stomach as you're getting that question. However you develop your list of questions, even if you don't have time and you've just done it yourself, we used to have a strategy at the AG's office for oral argument prep that involved making a written list of questions, and then we would have the advocate who's going to be doing the argument sort the list of questions in a Word document into categories. So the categories are topics about which questions might come to you, right? And so they're more than just sort of like areas of argument in your case. They are categories of underlying concerns that might be being expressed by a particular question. So it could be something like, counsel, why would I want to adopt your argument? Because if we do that, then this next parade of horribles is going to come down the pike at us, right? There's going to be some impact on the justice system or some impact on future cases. So one of my categories might be concern about future impact. So we would split the questions based on what we thought the underlying concern was into categories. So we had different, what we call buckets. And then we would develop, either as a team or the advocate would do this by themselves, 2 bullet points for each category. The bullet points were the first and second things that you should say in response to a question coming at you that's based on that concern. Then we would practice those initial answers to each category. So one of my friends who was an excellent advocate, she's now actually the chief of the Department of Ecology, but she was an excellent oral advocate when she was a practicing lawyer. She would take her list of questions and print them out and cut them into strips so that she had little paper questions all over the house. And she would put a bowl at the entry to every room in her house when she was prepping for an oral argument. And as she walked into a room, she had to pick up a question out of the bowl, read it, and then give her 2-bullet answer to the question. And those were prepping for state Supreme Court cases. She didn't do that for every single case. But the point is that you get practice sort of going to your first 2, your top priority answers for each category of question. Once we had done that, we would then encourage the advocate to look at the case overall and develop their top 3 things that they wanted to make sure that the judges heard during oral argument. And they'd put those 3 points at the very top of their oral argument notes. And then that would help people transition from a question back to an area that they wanted to be sure that they were going to cover. And that transition, for me, was the hardest thing to do at oral argument. You get to the end of an answer and you'd be thinking, okay, where do I go to from here? And having those top 3 priorities at the top of your notes always gives you the where do I go to from here? Because once you've covered all 3, then you've sort of won the oral argument game, right? And your job during oral argument is to make sure that those top 3 priorities get out in the midst of answering all of the questions. So that prep style is one strategy that if you feel like you're floundering and how do I get ready for these oral arguments, that is that's the strategy that the AG's office uses in their Solicitor General's team.
So we have a question, which is, how early would you like us to move for oral argument? E.g., when we file our opening brief or by the original date for our due date for our reply brief, or other, I think is implied.
Well, I would say as soon as you can. Typically, I think you'd want to wait until after all the briefing is done, so that you can identify any points of the disagreements that you're having with the respondent that would make it compelling for us to have oral arguments. So I think it would be much more effective to wait until after the briefing is done than to do it while the briefing is still going on. Judge Glasgow?
Yes, I agree. I think as soon as the briefing's done, you can do it, but I wouldn't do it before the briefing's done.
Right. Okay.
All right.
Let's see.
So the other thing that I've noticed that happens at oral argument quite a bit is that people waste their first sentence in the same way they sometimes do in their briefing. So oral argument is no different. And you can craft a 30-second introduction to your oral argument almost in the same way that you do for your brief. So we used to spend a ton of time talking and thinking about what the first sentence should be. But you can always do a classic roadmap. So we win for these 2 reasons, number 1 and number 2. Or we win for these 3 reasons, and then list your 3 reasons. Don't forget to work in passion and permission. And if at all possible, get to the crux first, because that's what oral argument is all about, is addressing that crux of your case.
Okay, so yeah, this is kind of seems obvious, but answer the question that was asked. Sometimes I think that lawyers will have, the list of the things that they really want to cover, and they're sometimes not listening closely to the question that was asked, and so they immediately continue on a track that is not germane to the question that was posed because we're asking it for a particular reason, and sometimes it's because they're dodging it. That's never really a good strategy. If the judge is having to ask you 2 or 3 times, or another judge has to chime in and say, you haven't answered so-and-so's question, you really need to just answer the question, even if doing so is going to be, you know, potentially bad for your case, you still need to address it. And so that's a big one, I think. So give the punchline first and explain, not the other way around. I think that's obviously the better way to go. Here's my answer. Here's why my answer is correct, instead of just getting into the explanation and then finishing with your punchline. So I think it's better to lead with that. And then the next one, practice transitions to get back to your high ground. That's really just getting off the ropes. And this kind of goes to what Judge Glasgow was talking about is, you know, identifying the problem. You know, when you're ready for the question, it's because you've prepared ahead of time that you think you're going to get that question. It's easier to get off the ropes. So having a good transition back to a point that you are wanting to, you've already made or that you want to make again, is a good way to get yourself off the ropes. Sometimes it's not easy. Sometimes the judge will keep chiming in, trying to get you back on the ropes, but you know, do the best you can. Sometimes another judge will tire of the exchange and chime in with a question of their own just to get things moving again. But Judge Glasgow, anything you want to add?
No, other than, you know, that being on the ropes is really hard. And we've all been there, right? Anybody that's been an advocate either in the trial court or in the appellate court has been there. One thing I used to always try to remember when that happened to me is that I wasn't just talking to the person who was asking me the question, especially at the appellate court, and especially at the state Supreme Court. You're talking to everybody. So everything you say, it may not be gaining ground with the judge who's asking you the question, but it might be gaining ground with other people on the bench. And so one of the most beautiful oral arguments that I ever saw was done by someone who learned like 3 days before the oral argument at the state Supreme Court that she was going to have to do it because the advocate had pneumonia and was in the hospital. And she's a judge now on the Superior Court in Thurston County. Her name is Karl Murphy. And she would do the Karl Murphy shoulder tilt, where she would take a question, an aggressive question from a judge 3 times. Once she got to the 3rd time, she would do this really beautiful smile and tilt her shoulders, which is easier to do at the state Supreme Court because you've got a broader bench. And unfailingly, that drew another question from someone who was like, okay, we're just done with this. And so I've always thought that that was a great strategy for getting off the ropes, in that, you know, 3 times is plenty of time to have a discussion about a particular difficult issue. And once you've gotten the same question 3 times, you definitely don't ever want to be rude about it. But using your body language and a very pleasant sort of facial expression, trolling for other questions from other judges can really work in that situation.
So we have a question. Would you describe again what you mean by passion and permission?
Mm-hmm. So Chief Justice Stevens talks about this, and she says it's really important to remember both anytime that you're working on an argument, either in writing or at oral argument. So by passion, what she means is it's important to think about why it is that the judges might want to rule in your favor. So is there an inherent sense of justice that you can draw on? Is there something about the justice system that you can take advantage of? For example, judges are really hesitant to expand the law a lot of times. They want to stay in safe territory. Is that is that part of the human nature of judges that you can tap into? Are there other things like that that you can use to tap into why a judge would feel really good about ruling in your favor? And sometimes sometimes in cases that can be hard to grasp onto, and you have to spend some time thinking about it. And then the permission part is telling us legally how we get there for you. So you have to do both, right? If your brief is all passion, but you don't tell us how the law gets you there, it's not helpful to us. But most often people will give us the permission part, but forget about the passion part. Judge Cruser, did you want to say anything else about that?
No, I think, I sort of describe it as bringing the heat. And, sometimes, you might not have a lot to work with, but sometimes you do have quite a bit to work with. A case that is going to be, that has, some compelling facts, maybe the state just grossly overcharged this case. Maybe, there's been a lot of prosecutorial misconduct. Things about that you can pull out of the record that paints a compelling picture of your client and why, whether you're challenging the sentence or the conviction, why it is, this sentence is crazy or whatever. You're trying to build that narrative that there's been an injustice here, and you immediately launch into here's what I can tell you about how you can get relief for this client of mine who I've just, painted a very positive, sympathetic picture of. And so, I think that, it may not work, it may not, but, the more that you can do that, again, while maintaining the proper tone. So when I talk about bringing the heat, I'm talking about really drawing out the things about your case that would be found sympathetic without in any way suggesting that there would be sort of too aggressive of a tone about it. But, that's what I would say about that.
And I used to represent state agencies, and so they are some of the most unsympathetic clients there are, right? Like it's hard to paint a sympathetic picture of that client sometimes. So we used to look for things like, what would my opponent's proposed holding do down the road that could be harmful for people that the court cares about? Or vice versa. What could our proposed holding do that's good for people that the court cares about? And often for us, that was taxpayers, right? Just shift the perspective a little bit to talk about taxpayer money as opposed to state agencies, right? So having that kind of mindset of trying to think through sort of how you can make your case more sympathetic. Okay. We just had one quick last slide about rebuttal argument.
Okay. And actually, Judge Glasgow, I don't actually see the slide. Is that for me?
Sorry, that's my fault.
Okay.
There you
that's
go.
all right.
Wrong screen.
All right. And so when you're, doing the rebuttal, one of the things that's interesting, the difference between a Court of Appeals argument and a Supreme Court argument, the Court of Appeals, it's more the Wild West, where you've maybe made 7 assignments of error and you aren't, oftentimes you'll know in advance what brought you there. I've prepared for a lot of oral arguments where I would say to myself, I don't know why I'm going up there, either because I thought I had a great winner or a big loser. I don't know why they want to talk to me. And then you're guessing about why they want you there. Or maybe you have a pretty good idea of why they want you there and you were completely wrong. It happens to everybody. So the rebuttal argument, of course, you've already seen. The state stood up and did their spiel, and you got to see already the first questions to you and the questions to them, and you've gotten a better idea of why you're there. So go straight there. If you don't feel as though you need to go over everything you went over when you first stood up. We suggest planning 3 points. You may not get that far. Again, it's going to depend on how much time you left yourself. And that's the other delicate dance. If you maybe guessed wrong about why you're up there and you spent more time than you planned in your initial argument than you've eaten in your rebuttal time, it can get really dicey. Don't trigger landmines and know when to sit down. Yeah. Don't reopen things that you are trying to avoid in your rebuttal. I will say that some of the judges it's the senior judge on the panel that will control essentially how the oral argument goes down. And I have not had that role yet, of course, but some of the ones that do seem to be fairly inclined to allow extra time for the parties to argue when there have been a lot of questions. It's a big difference than when I was a practitioner and certainly starting out. There was never any mercy. They would eat up all your time with questions and there was no extra time given because they did that. Seems like the culture is a little different now. Some of the judges are more inclined to say, oh, well, we took up, 3 minutes of your time with questions. We're going to add 3 minutes to your time. And in one of my early oral arguments on the bench, I thought, oh, this is new. I never got that when I was doing this. So this is interesting. But that's something I've been seeing a lot. And so don't be too panicked if you've run out of time, because often I think you'll get extra time added. I can't promise you that, but it seems to be happening quite a bit. So, but not in the rebuttal. The rebuttal is really where, okay, now we're ready to move on. But anything you wanted to add to that, Judge Glasgow?
No, that was good.
Okay.
Well,
all right.
Okay, thanks so much. I think that's all the time we have. But thank you, everyone. Thank you so much, everyone, for coming.